Caught me again, Chair. Thank you so much. Thank you for appearing today, and thank you for your submissions. Ms O'Shea, my questions are almost exclusively to you. Your recommendation 1 is to enact a comprehensive federal Human Rights Act. We already have one, as well as multiple international conventions to which Australia is a signatory. Is the problem Australians have no human rights, or is the problem our human rights are being ignored?
Senator, we don't have an enforceable Bill of Rights in the same way that other jurisdictions around the world do. So we do have technically a Human Rights Act, but it doesn't give rise to all the rights contained within the key conventions being enforceable for individuals. It does also result in a scenario whereby policymakers consider human rights implications but aren't necessarily bound by them, or courts aren't given the opportunity to make findings about how laws have been drafted and potentially rely on human rights, enforceable human rights to curb their interpretation of how those laws might apply. So in that sense, we do need a federal Bill of Rights that is enforceable. That is a gap. It is currently a gap in Australian law, and we remain the only liberal democracy in the world without one. That has all sorts of associated consequences. It means that in drafting a bill like this, for example, rights aren't taken into account, but a range of other services delivered by governments and policies implemented by governments aren't taken into account. It also means limitations on rights is not something that we discuss in Australia as a society and where they might be appropriate. Of course, there's very few rights, as you may know, that are complete or unable to be subject to limitation, that are absolute. And so there are circumstances where rights can be limited, but there needs to be a discussion and a dialogue about whether that's necessary and proportionate, appropriately limited and legal. We are miles behind in Australia because we don't even have these kinds of discussions, and that's a problem. So we absolutely need a federal Bill of Rights.
Thank you. Do you consider the balance between free speech and misinformation is fundamentally a human rights issue?
Fundamentally, I think lots of digital policy issues are human rights issues, but there are other components to it, of course. I think there are issues around competition in the size of online platforms, for example, and how they're regulated. I think there's issues around domicile and status of companies that are headquartered abroad who have, for all intents and purposes and tax purposes, headquarters abroad, how you regulate them in Australia and what you might do about it. So there's corporations regulation as well. So I think mis and disinformation touches upon multiple different fields of policy endeavour. Many of these have human rights components, and if we think about the right to freedom of speech, of course we think that should be protected, and we also think that people should be able to move in online spaces without surveillance by governments and private corporations. So there's a human rights lens to it, but there's multiple different factors that might be taken into account in regulating for the problem of mis and disinformation.
Thank you. That's very comprehensive. From your submission, misinformation issues are, I'm going to quote from you, exacerbated by the fact that commercial platforms are becoming the de facto distribution system for all forms of media content, including public service media and other outlets that have a mandate to take into account public interest obligations, accuracy and truthfulness. The result is that, for all practical purposes, the media ecosystem is increasingly shaped by a commercial model that profits from the amplification of polarising, sensationalist content, regardless of its accuracy. This is not a model compatible with democracy's need for well-informed citizens and meaningful political deliberation. That's the end of the quote. Are you opposing, limiting or removing private sector involvement in social media?
I'm not sure I exactly understand the question.
Are you saying we should be removing private sector involvement in social media, or restricting it in some way, or limiting it, or opposing it?
So social media companies are private sector companies. Am I proposing that they should be regulated? Yes. I think they should be subject to Australian laws, and that can include laws around content moderation. We do that in relation to e-safety, for example.
So you're not saying we should remove the private sector companies?
I'm not even sure how that would be practically possible, I must say, Senator. Maybe I've misunderstood the question.
Okay, so you're suggesting more regulation?
I think there's lots of regulatory reform that the Parliament could engage in that would be effective at improving people's fundamental rights, including as directed to social media companies, yes.
Thank you. Would that involve,
Last
or could it
question,
involve,
Senator Roberts.
could that involve understanding the algorithms and the behind-the-scenes activities of these companies? For example, shadow banning?
Well, that indeed is one of the proposals in this legislation, or this bill, I should say, that I think is encouraging. We've talked about it earlier in this hearing, that there would be greater transparency around how content moderation decisions occur, how amplification occurs on social media platforms. At the moment, there's almost no line of sight on that, except through very conscientious efforts by journalists and academic researchers. So we do need greater transparency in how social media platforms make the kinds of decisions that give rise to algorithmic amplification of all sorts of content, such as mis and disinformation, but also polarising and extreme content. I think that would be a worthwhile activity to include greater transparency and reporting to give people an idea of whether these businesses have earned the social licence to operate.
Thank you. Thank you, Chair.